law matters. Of course it does. Hi, I'm Debbie Moraes, your host and moderator. This program has been created to educate, inform, and help you with the law matters because the law matters. Understand the law better, and you're in a better position to understand how to protect yourself, your family, and your business. We provide information and resources that'll help you to determine whether or not you might want to contact a lawyer. Perhaps will help you to determine that you can handle some issues yourself. Either way, if you do decide to seek outside professional counsel, you will be better prepared, and so will your counsel. Our goal, of course, is to save you time, money, and of course, achieve the best possible results. We welcome and thank David Bazar, attorney Bazar, from the Bazar and Associates law firm in East Providence. They continue to provide their insights and information and counsel on the various issues that we tackle. In the past few weeks, we've been handling your questions, and another one has come up. This time we are going to discuss real estate, what you need to know, and how to avoid some problems, in particular with property ownership if it's joint property ownership. So of course real estate is among the most valuable assets that the average person will ever purchase in his or her lifetime. For many, buying a piece of land, a condo, or whatever means it's a good idea, or to consider pooling resources with someone else. Well, what are the pros and cons of that option? There are traps and there are perils, not surprisingly. So we thought this would be a good day to cover that. So David, what does joint tenancy, what does joint property ownership, concurrent ownership as the terms are, what are they? What are the options?
So there's joint tenants, tenants by the entireties, tenants in common, the most common forms of ownership. So tenants in common means that each of the owners of the property owns an undivided share that they, when they die, can leave to somebody else. So if there are 3 owners of a property and they each own it equally, and one of them dies, their share goes to their heirs, either by will or intestacy. Joint tenancy, those same 3 people, if one of them dies, the 2 survivors would own the property, and it would automatically pass by virtue of the deed and the form of ownership to the surviving tenants. And the third one that I mentioned, tenants by the entireties, would be husband and wife. And it's a special form of ownership that only husband and wife can have. There's protections in that form of ownership against creditors, and it again passes automatically upon the death of one of the spouses.
Sounds so nice and simple. Are all of the rules and laws about joint ownership the same in every state, or do they vary? Do we need to check on each state?
Yeah, well, certainly you would want to check on each state because property is a state right kind of situation. It's not federal law that really oversees that. So in different states, there might be different rules. For example, if a deed doesn't specify who owns the property, in what form, tenants by the entireties, tenants in common, what does that state default to? In Rhode Island, it defaults to tenants in common, for example. It might be different in a different state.
These things initially sound so simple and straightforward, but apparently they're fraught with many problems. I think this is our day to explore some of those. If someone has 3 potential owners, is it possible for them to be not 33 and a third, 30, but 50, 25 and 25? Are all of these options on the table?
Yeah, sure, that can all happen, and it can happen in a variety of different ways. The initial deeding the property to the people might say, I deed 50% of my ownership in Blackacre, that's what we always had in law school, Blackacre or Whiteacre, to Deb, and 25% to David, and 25% to Susan. And so right in the deed, that ownership is laid out. There are other ways that it can get changed over the course of time. David and Susan may have bought 25% each, and Deb and Cass may have bought 25% each, and if Deb dies and leaves her share to Cass, now he owns 50%, and Susan and David still own their 25%.
All of those things need to be set out in stone before you proceed, you go through these things. How about by floors or condos? If someone has a one part of the condo or 2 floors of an apartment within a condo, how do those things get portioned?
So the ownership of, this gets into a little bit of how do you divide up property if you can't agree, and we're not quite there yet.
Not quite.
But if the property can be divided up by what they call meets and bounds, which is by, you have a 10-acre parcel of land, all the land is basically the same, and you can say, all right, you're going to get 5 acres and you're going to get 5 acres and divide it that way. If a condominium can be divided up in different ways, there's a possibility that we could have one building, using your condominium example.
Okay.
And you own one condominium in the building, which is comprised of 25% of the space, and somebody else owns a condominium that's comprised of 40% of the space, and the remaining percentage of the space is owned by a third person. The condominium documents then have to lay out what your responsibility is for the common area maintenance and the condominium fees and all of those types of things. So they could be divided up in terms of the square footage percentage that each of the units occupy.
Versus on floor 1 is where Deb and Cass will reside, and on floor 2 is where David and whomever.
It could still be that way.
Okay.
And it depends on how the condominiums are laid out, and of course on the condominium documents, which are very critical in that situation.
So when you invest in, whether it's a condo or a house or whatever, for many, that investment involves a long-term financial commitment, and circumstances change, people change, things change. It seems that that's where potential problems lie, even if you are all in accord as you are at the day's signing or purchase or whatever. So to carry on your example, we're very happy with how we arranged our agreement, and then I don't know, I didn't pay my portion of the taxes, or I didn't pay my portion of something else. You're stuck? Is that how that goes?
Not necessarily. So we'll take your example, and I'll lay another example on too, which is a little bit even more common as to when these things typically arise. But another form of ownership would be someone who reserves a life estate interest in a piece of property. So a parent deeds her property to her 4 children, subject to her life estate. So what that means is she's given each of her 4 children a 1/4 interest in the future ownership of the property, and she retains the ownership for as long as she's alive. So while she's alive, it's her property. She owns it, but she doesn't own the future after she dies. So what happens in that circumstance is when mom dies, the 4 children now inherit it. And oftentimes there's a difference, a divergence in what they want to do with that property. So 3 of them want to sell it, 1 of them wants to buy it. The one who wants to buy it isn't really cooperating with the other 3 who want to sell it. So what can they do? They can file what's called a petition to partition. In Rhode Island, that's a suit that's filed in Superior Court. It's a complaint brought to the court that says this is property that cannot be divided by meets and bounds, as we talked about before. It's not a 10-acre parcel of farmland that we can give 1/4 of that to each sibling, but rather it can't be divided that way. So the only way to divide it is either to sell it and split it amongst the 4, or in this instance, maybe the one who wants to buy out the other 3 is given some time to come up with financing to do that. So that's a case, you bring it to Superior Court. You can either resolve it like you can resolve any case by agreement, or you bring it to the judge to bring to a resolution.
Okay, and suppose just those original owners, one of the 2, one of the 3 owners or whatever, suppose they start to renege and not uphold their end of the bargain. What are you as one of the other owners or one of the other 2 owners, are you stuck with that, David?
No, again, you can bring that same kind of suit.
So you do the same thing.
And force them to either pay or be bought out or do something with it so that they're no longer going to be an owner of the property.
So in these different joint tenancy in its entirety, and the third one that are there issues that make it more difficult for me? Which one makes it least difficult for me? If I'm not sure I'm going to like who you might, as the partner, sell it to or pass it along to, I might not like. What choices do I have, and what is my best protection to make sure that I'm covered in those happenstances?
We need more information.
Okay.
So if the situation is, if you're coming in and there are these unrelated parties buying a property and they're afraid of having an ownership interest with somebody that they don't want in it, and it's an investment type of property.
That's a good example, okay.
So then what they probably should do is form a corporation to own that property, an LLC or a C corporation, and now that all depends on the change in the tax law and which is a better way to hold it for tax purposes, whether you want a pass-through entity or not. But let's just simplify it a little bit and say we're going to form an LLC. And in the LLC, we're going to put rules in that say who can own an interest in the LLC, which gives some protection as to who may be your partners in the property, rather than trying to do it just through a deed where you're not going to have a whole lot of success in being able to control that without running afoul of some property laws, real estate laws. So LLC or a C corporation, where you can say that that's a stock ownership corporation, who can own the stock, who can't own the stock, whether it has to be offered to the surviving partners first if you die or not. So there's a lot of different ways you can protect who the owners are of a piece of property through that mechanism.
So you're talking about it having another entity versus a simple joint ownership where I might want protection so that my partner, whoever I own that with, might be selling it to an undesirable and I don't even have the right of first refusal,
right.
Or I don't have any input.
Yeah,
I'm in trouble.
That's why I'm saying have the corporate entity own the property instead. Or a partnership agreement where the partnership owns it. And again, you can consult with an accountant first to find out which is the best for tax purposes to hold that investment property. However, from a legal perspective, we can craft partnership agreements or shareholder buy-sell agreements or LLC operating agreements that can cover all of those things. Now, in a family situation,
that's where I was going to go next, which
is
seems
where I assume you might be going next.
Yes.
There are other ways that we might deal with that. And again, you could do a corporation to hold some real estate, but that might not make sense. Sometimes it does. A family limited partnership is used oftentimes, but I'm not sure that it may or may not be necessary for what you're trying to get at with just some residential property perhaps. But if there are enough assets, and we've had this conversation about avoiding probate and that type of thing, a trust might be the answer to forming the owner, to have as the owner of the piece of property, with the instructions in the trust that say who can and cannot own it as the survivors of the beneficiaries that you've named in the trust.
So I understand from doing a little homework here that families, two brothers get together and they decide that they want a piece of property, and they just decide that it will be so much easier. What do they call it? The poor man's will. We'll just have a joint ownership here and no troubles. If someone comes to you in this day and age, if someone comes to you with that kind of circumstance, would you automatically say, don't just go with this simple joint partnership, let's explore some of these options because you can't imagine what's going to happen down the road?
Well, it depends on what they really want to accomplish. So it's two brothers, and they have spouses.
And they might have kids later on.
And they have children. And what they've done is they've set up a situation where they bought this investment, they work on it equally, they put into it equally, and they're making a bet with each other. Who's going to survive? Because what they've set up is a real estate owned by joint tenancy that's going to pass to one or the other upon the death without probate or will or anything else. And if we've developed this piece of property and we put money into it and we built it up and we now have an asset with an equity of about $1 million, and we don't mind that our $500,000 goes to our brother and not our children or our spouse, then that'll work. But is that what you really intend to do?
So imagine then if this continues as two brothers who made this investment. They had kids, their kids had kids. It's 3 generations down. Somebody had 1 kid, the other one had 5. Subdividing that property out, how do you anticipate or how do you help walk someone through what might happen 3 generations down the road, where those 4 can't buy out the 1, or the 1 can't buy out the 4, or doesn't want to? That can be such an incredible nightmare, as we've seen happen.
Well, again, if there are 2 brothers and the 2 brothers each had 2 children, and one of the brothers' 2 children had 4 and the other one had 6, it doesn't really matter, because if they did it the way you said, it's never getting to the other family.
Kids.
So it's just that one brother's family, and then he's got to deal with his own family and how he wants it divided up by his will or intestacy. Which is why I said, if that's not what they intend, they're much better off having an LLC or some other form of ownership, corporation, partnership, that has the instructions in it as to how you deal with all of those factors that you just raised.
So we've talked before about how sometimes people can handle some issues themselves. As I review some of this, and of course you deal with it daily, or maybe not daily, but often, the number of options and pitfalls and traps that need to be anticipated seems clearly that this is not something one wants to go it alone with.
No, and it's not even so much, we've talked about this before, you can get the forms online, you can fill the forms out, but it's the advice. And it's, all right, I can go online and I can do that deed, joint tenants, and file the joint tenancy, but I haven't gotten any advice from any professional as to whether the 2 brothers want to really do that. And one brother might be thinking, well, I know my other brother's going to make sure he shares it with my family, so I'm not worried about it. But is he really? And do you know that? And are you protected against that? And do you really want to do that? And it's the advice in talking it through with an attorney as to what all of the possibilities are that could come up and become issues down the road that you either don't want to think about or haven't thought about. So that's the value added from the attorney, in addition to making sure it's done correctly.
Of course, in most of these documents there are terms, there is legalese. Help us with some. So in discussing what joint tenancy is about, there are 4 complicated requirements. Who better than you to explore these? So what are the 4 unities? Rights in terms of time, title, interest, and possession for all joint tenants. When someone comes across from that, what do those mean?
Yeah, so you receive the property at the same time. Okay. That's one of the unities. The same right of possession, the same ownership interest. What was the fourth one?
Interest.
Yes, you have the same interest in the property.
And possession for all joint tenants.
Meaning that they all are allowed, you all have the same right to possess the property.
Fairly simple and straightforward.
Yep.
Okay.
Right. And so you can break a joint tenancy.
And how does that happen?
So one of the ways to break it is the time. If you didn't receive it at the same time, then you don't have a joint tenancy. So oftentimes, people have property that they received as joint tenants, and they're, for whatever reason, not one of them doesn't want to retain that ownership in that fashion, so they do a deed to somebody else, who then deeds it back to them. So now their ownership is tenants in common with the original person, because they don't have the unity of time. They didn't receive it in the same deed, because they deeded their interest out and then it was deeded back at a different time.
What an interesting wrinkle that is, David. What happens when there's joint tenancy in common?
Tenants in common.
What happens with the awful situation if the 2 brothers die simultaneously and they haven't had a chance to prepare wills and don't have LLC? What happens with this? There's probate, what happens?
I think it is an issue that will then have to be determined by a court as to which brother survived. Because where did they die? In a plane crash?
Okay.
All right. If a legal determination can be made as the time of death of brother 1 versus brother 2, then that's going to be critically important in that situation.
What a wrinkle that is, too.
Yes, it is.
So there are issues about husband-wives. You talk about tenant in its entirety.
Right.
What are the wrinkles that one should anticipate with that? I understand that can be fraught with problems as well.
So there here's an interesting situation with that. Again, it's the best way to own property as husband and wife because there are the most protections that you get against creditors and that type of thing. And I've had some interesting cases. One thing you need to know is if you get divorced and you haven't done anything with the property in the divorce, tenants by the entireties doesn't exist anymore. Now it becomes tenants in common because one of the unities of a requirement for tenants by the entireties is that you be married. So if the marriage ends, the protection under tenants by the entireties also ends.
Would that also mean then that the spouse is no longer liable for the other one's debt because there's been a divorce?
Well,
and how does that
no,
work?
you lose that protection.
You lose that protection.
While you're married, if the husband, let's say, has creditors who file liens against the property because he owed money and he didn't pay it, and you're married, and he dies, those liens go away. That's the protection provided by tenants by the entireties because they can't attach the property under that circumstance, and if he doesn't survive the wife, the lien doesn't survive him.
So if someone is married, they're divorced, not a death, maybe one wants it, but
Right.
didn't happen,
Right.
but there isn't a death, just one refuses to pay the real estate tax. Theoretically, they're not in entirety anymore because you say
Right.
they have to be married, so that would mean that the other spouse does not have to pay for the real estate that the other one reneged on?
Make it a different example than taxes. Make it utilities that
Okay.
there's a judgment.
Why is there a difference, David?
Well,
Or was-
because the taxes, you're both responsible for paying.
No matter what?
Well, because you both own the property.
But not if you've been divorced and
Well,
they didn't,
but your name's still on it.
it's still on it. That's the issue
That's
with that.
what we're
Okay,
talking about.
okay.
All right. If your name's off the property,
Quitclaim deed.
doesn't
then
matter,
okay.
husband, wife, otherwise, if you don't own it, the owner's the responsible party for the taxes. But if there's a judgment and you still own the property, you don't have the protection of tenants by the entireties against the ex-husband's creditors that you would have had otherwise. So it's a
Okay.
problem. So you want to be very careful with what you're going to do with property after a divorce, when it was owned tenants by the entireties.
Good to know. What about when you jointly own property, and we were talking a little bit about who else might own it. How about if it's not owned, but an unexpected use? So for example, all of a sudden the idea of Airbnbs or sub-rentals. I'm not sure I want you to sublet that condo that we have together. Do I have any options about that if I haven't already anticipated that and specified that?
So we're co-owners of the property, joint or tenants in common or whatever.
Yes.
So you have certain rights depending on the ownership, tenants in common, joint tenants, whatever it may be, to specify who can live on the property, who can use the property, what the rights to collect the rents from the property, and the benefits of the property. In the old days we used to talk about the wood rights, the natural rights, those types of mineral rights. So as an owner, you still have say and control to some degree over those things. So based on that, I would say that if things are being done that you don't want to be done with the property, you either have to work that out or bring it to court.
So if you didn't specify it early on, maybe Airbnb hadn't existed at the time. Now my only recourse is to have an occasion to re-discuss this in a court situation, or just two lawyers? Or?
Yeah, I mean, it depends. And you can always resolve issues between parties, so it can be done between lawyers, it can be done between the parties. You could say, you know what, it's not what I wanted, buy me out, for example.
Can anybody be forced to buy the other out?
It's what the petition for partition is.
And
It
can
doesn't force it, it leaves it as an option
but not a...
rather than selling it out totally.
Okay, okay. Again, what about the story about somebody's collecting rents now, if we're talking not an Airbnb, but maybe someone chooses to rent out part of their unit? You didn't know it, but I rented it out 4 times, and we're all supposed to be sharing that. You didn't know it, you did know it.
You can sue for your share of the rents.
You can. And is it always based on half-half if there are two of us?
Depends on the ownership and
50,
any
25, 25.
agreements or otherwise that might exist.
What happens if along the way one of the owners, joint owners, suddenly becomes incapacitated, can't handle his or her responsibilities or even options to decide that we need a new roof? What happens then, David?
So hopefully the person who's become incapacitated has a power of attorney, which we've discussed on previous occasions, so somebody's able to step into his or her shoes and make decisions for them and take care of their investments, including the real estate. And as we were talking before about rents and we talked about expenses, just to go back on something, anytime somebody's not paying their fair share or receiving their fair income from property, they can bring suit on those issues. It doesn't have to be a petition to partition. It can be a suit for contribution or a suit for your share. But if this person isn't doing it because they just don't know because of their mental condition or capacity, then you need either to have the power of attorney step in, or if they don't have one, a guardian needs to be appointed to take care of their issues.
So in these examples that I've tossed out to you, David, does it seem more likely that when these wrinkles or these issues occur, can most of them be settled between a mediator, 2 lawyers, rather than it going to full-blown litigation?
Absolutely. There's no reason why parties can't sit down together or with the help of an attorney or a mediator and just say, all right, here's how we're going to resolve it. And there are innumerable ways to say, okay, we're going to enter into a new agreement that says I'm going to pay X, Y, and Z, and upon sale of the property, I'm getting paid back first, and then we'll split what's left. There's a lot of ways to resolve issues.
We've touched on so many different things. Obviously, there are enough situations that say this idea of joint ownership can go awry. Usually better to see the lawyer first and settle it, whether it's LLC, incorporation, or whatever else, rather than having to come back and try to iron it out later.
Sure, what do they say, an ounce of prevention?
Worth a pound, even with these wrinkles that you cannot anticipate.
Sometimes you can't, lawyers might be able to. That's what they're paid to do sometimes.
Good to know. We hope that this has been helpful to you in dealing with property and joint ownership. We're glad that you tuned into The Law Matters, because certainly the law matters to you.